A very good day to you. Today we are going to continue with the next topic, which is discharge of contract. So, a contract is discharged when the rights and obligations of the parties come to an end. Once contract is discharged, the parties are no longer legally bound to perform it. A contract can be discharged in four main ways. Number one, discharge by performance. This happens when both parties fully perform their obligations. What was promised has been completed, so the contract ends naturally. Number two, discharge by agreement or consent. This happens when both parties agreed to end, vary, or replace the contract. For example, by mutual cancellation or substitution. So here, the contract ends because both sides consent. Number three, discharge by frustration. This happens when performance becomes impossible or illegal due to events beyond the control of the parties. For example, there is a destruction of subject matter, or probably there is a change of law. So the contract is automatically discharged by law. Number four is discharge by breach of contract. So this happens when one party fails or refuses to perform their obligation. The other party is entitled to treat the contract as discharged and may claim damages. So the point for you to remember here on the discharge of contract, number one is that discharge means end of contractual obligation. And there are four modes where the contract can be discharged. Number one is performance. Number two is agreement. Number three, frustration. And the last one is breach. So once discharged, the contract has no further effect. Now, let's look at discharge by performance, which is the most usual mode of discharging a contract. At the start, when a contract is formed, both parties are legally bound to perform what they have promised. Once the parties perform their obligations, the purpose of the contract is fulfilled. Now, under the legal provision, section 38 subsection 1, once a contract is performed, the contract is discharged. There are no more obligations left for the parties. The law also states if only one party has performed, that party alone is discharged from further obligation. The other party is still bound to perform their part. Meaning, the performance is doing exactly what you promised in the contract. Once performance is completed, the contract comes to an end, and no party can demand anything further under that contract. Okay, so the key point for you to remember that discharge by performance is the normal and usual method. Once performance is complete, the contract ends. If only one party performs, only that party is discharged. And this is based on section 38 subsection 1. Time for performance. Now we will discuss time for performance in a contract. When parties enter into a contract, they may agree that the contract must be performed within a specific time. Whether a delay affects the contract depends on whether time is essential to the contract. When time is essential, which is important, if time is essential to the contract, any delay in performance by one party gives the other party the right to cancel or void the contract. Under Section 56, subsection 1, he states that if a party promises to do something at or before a specific time and fails to do so, and time is intended to be of the essence, the contract or the unperformed part becomes voidable at the option of the promisee. However, if time is not essential, then delay does not cancel the contract. Under Section 56, subsection 2, it says that the contract does not become voidable, but the promisee is entitled to compensation for any loss caused by the delay. So the contract continues, but the delayed party may have to pay damages. Okay? So the key point for you to remember here is that if time is essential and there is a delay, then the contract is voidable. However, if time is not essential, then there is no cancellation. Promisee can claim compensation, and this is governed by Section 56, subsection 1 and 56, subsection 2. Place for performance. Now we will look at the place for performance of a contract. When parties entered into a contract, they may agree on where the contract must be performed. The law provides clear rules depending on whether the place is specified or not. Rule on place for performance. Number 1. Place is specified. If the contract clearly states the place of performance, the promiser must perform the contract at that stated place. There is no choice to perform it elsewhere. Number 2, if place is not specified. If the place is not mentioned in the contract, the promiser must ask the promisee to specify a reasonable place. Performance must then be carried out at that place. This rule ensures fairness and avoids uncertainty. Now let's look at an illustration under Section 50. A undertakes to deliver 1,000 gantangs of rice to B on a fixed day. A must apply to B to appoint a reasonable place for receiving it and must deliver it to him at that place. Okay, so a key point for you to remember here is that if place is specified, then he must perform exactly there. However, if place is not specified, then the promiser must ask the promisee. Performance must be at reasonable place. This is governed by Section 50. Now we will look at who must perform a contract. The general rule is simple. A contract must be performed by the promiser. However, whether the promiser must perform personally depends on the nature of the contract and the agreement of the parties. The general rule is that if the contract requires personal performance, then the promiser himself must perform the contract. These usually apply where personal skill, personal qualification, and personal judgment is involved. Let's look at Section 41, an illustration. A promises to pay B a sum of money. This promise may be performed by A personally paying B or A arranging for another person to pay B on his behalf. If A dies before payment, A's legal representatives must perform the promise or appoint a suitable person to do so. So the personal performance is not required here. Okay? However, in some cases, okay, the promiser may employ a competent person to perform the contract. But remember, the promiser remains personally liable. If the performance is defective, the promisee can still sue the promisor. So the key points for you to remember here is that contracts requiring a personal skills, the promiser must perform it personally. If the contracts involve money or generic acts, other may perform it. Even if someone else perform, the promiser remains liable. This is governed by Section 41. Okay. Next, now we are going to look at performance by third party. Normally, a contract must be performed by the promiser. However, in certain situations, performance may be carried out by a third party. The legal effect depends on whether the promisee accepts that performance. Legal provision under Section 42 explains the effect of accepting performance from a third person. It states that when a promisee accepts performance from the promise from a third person, the promiser is discharged from further liability. After accepting such performance, the promisee cannot later enforce the contract against the original promiser. Meaning, if the promisee agrees to accept performance from a third party, the contract obligation is treated as fulfilled. The original promiser is released. The promisee cannot demand the same performance again from the promiser. Okay, so for you to remember, there's an important limitation here that this rule applies only if the promisee accepts the performance. If the promisee rejects the third party's performance, then the promiser is not discharged. So for you to remember in this particular point here is that performance made by third party only crucial when it is accepted by the promisee. Once accepted, the promiser is discharged. Promisee cannot later sue the promiser. This is governed by Section 42. Next, let's look at discharge by agreement. A contract may be discharged when all parties agreed to bring the original contract to an end. This is done through substitution, alterations, or rescission of the original contract. Once the party agree, the old contract is discharged, and the parties are no longer bound by it. The legal provisions of Section 63 allows parties to substitute a new contract or alter the terms of the existing contract or rescind or cancel the contract altogether. So any of this agreement will discharge the original contract. So illustration given to you under Section 63, A owes money to B under a contract. It is later agreed between A, B, and C that B will accept C as the debtor instead of A. So what is the effect? So the all debt from A to B ends. A is discharged. A new contract arises between C and B. So this is called substitutions of contract. So important requirement here for you to remember and understand is that the agreement must involve the consent of all parties concerned. If any party does not agree, then the original contract is not discharged. And a key point for you to remember here is that discharge by agreement requires mutual consent. It can occur by substitution, alterations, or cancellation. And this is governed by Section 63. and the consent of all parties is necessary. Now, earlier we learned that the contract can be discharged by agreement, such as through substitutions, alterations, or rescission. However, there is an important rule that all parties to the agreement must give their consent. If any one party does not agree, then the whole contract is not discharged. Okay? So, under the legal provisions of Section 63, saying that contract by agreement, but only when consent is given by all parties involved. Without full consent, the original contract continues and no new contract is formed. So let's look at the illustration given under Section 63 here in these slides. A owes B 1,000 ringgit under a contract. B owes C 1,000. So B order A to credit 1,000 to C's bank account. C does not agree to this agreement. So what is the legal effect here? Since that C does not give any consent, the whole contract between B and C continues. B still owes C 1,000 ringgit. And there is no new contract is created between A and C. The original obligations remain unchanged. The whole contract is not discharged. So, simple explanation for you is that substitutions or transfer of obligation requires approval from everyone involved. Missing a consent means there is no discharge. Discharge by agreement. A contract can also be discharged by agreement in the form of waiver, release, or remission. This means the promisee voluntarily gives up his right to insist on full performance of the contract. So under legal provision section 64, the promisee may dispense with performance of the promise or remit. Remit here means reduce the performance wholly or partly, or extend the time for performance, or accept any satisfaction instead of the original performance. This can be done without any new consideration. Once the promisee waived the performance, the promiser is discharged from further obligation. So let's look at the meaning. When we say waiver, it means that the promisee gives up the right to performance. Release means promisee frees the promiser from liability. Remission means promisee accepts less than what was promised. All these results in discharge of the contract. Okay. So let's look at the illustration given in this slide. A promises to paint a picture for B. Later, B forbids A to do so. So what is the result? The result is that A is no longer bound to paint the picture. The contract is discharged by waiver. So key points for you to remember here is that discharge can be by waiver, release, or remission. It is done by the promisee, and there is no new consideration required. It is governed by Section 64, and the promiser is discharged once it's being waived. Let's move on to the next one. We are going to look at the discharge by frustration. Frustrations occurs when a contract cannot be performed, not because of the party's fault, but because the act is impossible. There are two situations of frustration. We will start with the first situation. Situation number one, the contract is impossible from the beginning. The first situation is where the contract itself is impossible to perform from the start. So the legal provision under sections 57, subsection 1 states that an agreement to do an act which is impossible itself is void. This means if the act agreed upon cannot possibly be done, the agreement is void from the beginning, meaning there is no valid contract exists. So the law will not enforce something that is clearly impossible. If we look at the illustration given in the slides, the illustration says that A agrees with B to discover treasure by magic. The agreement is void. Why? Discovering treasure by magic is impossible, right? Therefore, the agreement is void. So there's no legal obligation arises. So the key point for you to remember in this particular slide is that frustrations can occur when the act is impossible from the start. Agreements to do impossible acts are void. It is governed by sections 57, subsection 1, and there is no rights or duties arise under such agreement. Next, previously, we learned that contract is void if the act is impossible in itself. Now, we look at another important rule under section 57, subsection 3. The important rule here is that even if one or both parties are aware of the impossibility, the contract is still discharged. However, liability for compensation may arise. Under the legal provisions of section 57, subsection 3 states that if a person promises to do something that he knew or should have known to be impossible or unlawful, and the other party did not know of this impossibility, the promiser must compensate the promisee for any loss caused by non-performance. So although the contract is discharged, the innocent party is protected by compensation. So let's look at the illustration given here for section 57. The illustrations explains A contract to marry B. A is already married to C. A is subject to a law that forbids polygamy. Because of the law, A cannot legally marry B. The contract is impossible and void. However, A knew he could not legally marry B, and now B may have suffered loss. So, A must compensate B for the loss caused by the non-performance. Okay, so simple explanation for you is that contract going to be void if it's impossible. But if the promiser knew the impossibility, so he must pay compensation to the other party. Okay, so the key point for you to remember here in this particular point is that contract is discharged due to impossibility. It applies even if parties knew the impossibility. Promiser who knew is liable to compensate, governed by section 57, subsection 3, based on fairness and protections of innocent party. Now, discharge by frustration or supervening impossibility, right? So under section 57, subsection 2, here we are now moving on to the second situations of frustration. This situation happens when the contract is valid at the time it is made, but later become impossible or lawful to perform. This is known as supervening impossibility. Okay, so under legal provisions, section 57, subsection 2 states that a contract to do an act which after the contract is made become impossible or unlawful becomes void when the act becomes impossible or unlawful. Okay, in simple words, the contract starts as valid. A later event occurs beyond the control of the parties. Performance becomes impossible or illegal. The contract is automatically discharged, and no party is at fault. Okay, so simply we can say that supervening means happening after the contract is formed. The impossibility arises unexpectedly. So neither party intended the problem. So the law releases both parties from their obligation. Okay. So please remember, contract is valid at the beginning. When it becomes impossible or unlawful afterwards, then it's due to supervening impossibility. The contract becomes void automatically, and this is under section 57, subsection 2. Okay, so let's look at supervening impossibility, a case, Taylor versus Caldwell. Okay, now here we are going to look at one common situation where supervening impossibility occurs, and that is a destruction of the subject matter. Okay, so please remember that supervening impossibility happens when the contract is valid when made, but later becomes impossible to perform due to events beyond the control of the parties. So if you look at this case, Taylor versus Caldwell, the fact of the case is that a music hall was rented by the plaintiff from the defendant. The hall was to be used for a series of concerts. Before the concert's death, the hall was accidentally burned down. The destruction was not the fault of either party. Okay, so what is the issue here? Can the contract still be enforced even though the subject matter no longer exists? So the court held says that the contract was is void due to frustration. The performance became impossible because the subject matter was destroyed. So neither party was liable for breach. Okay, so for the legal principle here, for you to remember is that if the subject matter essential to the contract is destroyed, then the destruction occurs after the contract is made, then the contract is discharged by frustration. And this falls under section 57, subsection 2, under supervening impossibility. Okay? All right. So let's look at another case. Okay? Another situations of supervening impossibility. This happens when the contract can still be performed physically, but a supervening event destroys the whole purpose or object of the contract. So when the main purpose fails, the contract is said to be frustrated. Now let's look at Krell versus Henry. The fact of the case is a room was hired by Henry. The sole purpose of hiring the room was to watch the coronation procession of King Edward VII. Before the event, the king fell ill, so the coronation procession was cancelled. So what is the legal issue here? Even though the room still existed, does the cancellations of procession discharge the contract? So the court held says that the main purpose of the contract was to watch the procession. Once the procession was cancelled, the foundation of the contract disappeared. So the contract was therefore frustrated. Henry was excused from paying the rent. Okay, so if a supervening event destroyed the essential purpose of the contract is discharged by frustration. So even though performance is still physically possible, and this falls under section 57, subsection 2, the supervening impossibility. Okay. Now, next, still under supervening impossibility, which is the death or personal incapacity. Okay, so this applies especially to contracts that require personal skills, personal qualification, and personal performance. So when the person is no longer able to perform due to death or incapacity, the contract becomes impossible to perform. Under Section 57, subsection 2, a contract which becomes impossible after it is made becomes void when the impossibility occurs. Death or serious illness is considered an event beyond the control of the parties. So let's look at an illustration for Section 57. A and B contract to marry each other. Before the time fixed for marriage, A goes mad. The contract becomes void. So what is the explanation here? The marriage requires personal capacity. However, once A loses mental capacity, performance becomes impossible. So the contract is discharged by frustration. Okay, so let's look at another illustration given. A contract to act at the theater for 6 months for payments made in advance by B. On several occasions, A is too ill to act. The contract to act on those occasions becomes void. So what is the explanation here? Acting requires personal skill and health. Illness prevents performance. So the contract is frustrated for those affected occasions. Okay, so a key point for you to remember here is that applies to contracts involving personal performance. Death or serious illnesses makes the performance impossible. So the contract becomes void due to frustration. Okay, it is governed by Section 57, subsection 2. You can look at the illustration given in the slide, okay, for understanding. Next, still under supervening impossibility, where there is a change in law or outbreak of war. Okay, so another situation where the contract may be discharged by frustration is when there is a change in law or an outbreak of war. Okay, this happens when the contract is valid at the time it is made, but later becomes illegal or impossible because of new law or war. The key point is that the impossibility must be beyond the control of the parties and not caused by any party's fault. Okay, so legal basis, Section 57, subsection 2 says that a contract becomes void when performance becomes impossible or unlawful after the contract is formed. A change in law or declarations of war is a classic example of this rule. So there's an illustration given to you in the slides. A contracts to take in cargo for B at the foreign port. A government later declare war against the country where the port is situated. The contract becomes void when war is declared. So the explanation is that war makes performance illegal or impossible. So the contract is discharged automatically and no party is at fault. So let's look at a case, Lee Kin versus Chan Xuan Eng. The principles of this case is that a lease for 5 yearly renewals was made. A new law was later enacted requiring annual renewal. So this defeated the original contractual agreement. So the decision is that the contract was held to be frustrated due to change in law, not the fault of the parties. Okay, so key point for you to remember here is that it applies when law changes or war breaks out, the performance becomes illegal or impossible, so the contract is discharged automatically and must be no fault of either party, and it is governed by Section 57, subsection 2. Now, when a contract is discharged due to impossibility or frustration, the legal effect is clear. Okay. Now, when a contract is discharged because of impossibility or frustration, the contract becomes void. Okay. The parties are released from further obligations, and neither party can sue the other for non-performance. This is because the failure to perform is not the fault of either party. However, there is an important rule about benefits already received. If either party has received any benefit or advantage under the contract before the contract was discharged, that party must return the benefit to the other party. The law does not allow a party to unjustly enrich himself after the contract is discharged. Meaning, contract frustrated means no damages and no lawsuit. However, when there's money, goods, or benefits already received, it must be returned. This restores fairness between the parties. Okay. Let's continue for section 66 under the Contract Act. Okay. The restitutions of benefit. So when a contract discharged because it becomes void due to impossibility or frustration, the parties are no longer bound to perform. As a general rule, the party cannot sue each other for non-performance because the failure to perform is not due to anyone's fault. However, the law imposes that an important duty regarding any benefit already received. So the legal provisions, section 66 states that when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage or benefit under the contract must restore it or make compensation for it to the person from whom it was received. This rule is based on fairness and prevent unjust enrichment. So, in simple words, what section 66 means, contracts becomes void, then there is no damages and no lawsuit. But money or benefits already received must be returned. Let's look at the illustration given from the slide. A contract. A contract to sing at the concert for B. B pays 1,000 in advance. Before the concert, A becomes too ill to sing. So what is the legal effect here? The contract becomes void due to frustration. A is not liable for B's loss of profit, but A must refund 1,000 ringgit paid in advance because A has received a benefit under a contract that became void. Okay, so I hope you can understand. So remember, frustrated or void contract means there is no right to sue. This is governed by section 66. However, any benefit received must be returned and no compensation for loss of profit. The purpose is to prevent unjust enrichment. Right? So thank you very much. That's all for this topic, discharge of contract. I will see you guys again on our next topic. Thank you very much.